The judgment.
In the matter of PHL.
Yes, good morning.
Good morning, my lord. My lord, I appear for the appellant in this matter, Mrs. P, and my learned friend, Mr. Heffer, appears for the father, and my learned friend, Mr. Gratian, appears on behalf of Kafkas Legal on behalf of the guardian. My lord, I hope that you have 3 bundles, the core bundle, a supplemental bundle, and a bundle of authorities.
I'm not actually sure I've got a supplemental bundle. I thought everything was in one rather fat bundle, which I have.
My lord, it may well be that that combines.
Well, I have a supplemental bundle, which, if anything, is fatter than the core bundle.
Yes, my lord, that may well be the case.
I mean, the bundle I have has sections headed A, B, C, and D, and runs through to page D133.
That I think is the core bundle.
That is the core bundle. In that case, I don't, at the moment, seem to have the supplemental bundle. I'm sorry about that.
Yes, my lord, that is. I'm just checking how many pages the. Yes, my lord, I think that is the supplemental bundle, my lord.
Well, it must be the core. Well, there's section A is headed core bundle in my thing, and then section A, and then section B, documents referred to in judgment, section C, miscellaneous, and then I have section.
My lord, I wonder if you have a further section A.
I do have a further section A.
Yes, I think that is therefore the supplemental bundle.
I see. Well, that may be the answer.
Supplemental bundle, my lord.
It begins rather oddly with the skeleton arguments, which I might expect to be in the core bundle.
Yes, my lord.
Okay,
yes.
well, in that case, I think I do have
I'm grateful.
everything, because I do then have a section beginning A, B, C, D.
I'm grateful, my lord.
And what is the core bundle then, with subsections A, B, and C?
Yes, I will do my best to ensure that the appropriate page references are given. I'm afraid the supplemental bundle was slightly larger because the core bundle was required at a very early stage prior to my learned friends having produced their skeleton arguments.
Yeah, well, the main thing is we have all these, I think, got all the material. It looked for a nasty moment as though I only had half of it.
I'm very grateful, my lord. My lord, I bring this appeal. It is brought on 3 main issues in relation to a judgment given in March of this year in relation to a little boy who is now aged 4 and who has been living in foster care since October of last year. My lord, I will not repeat the detail of the circumstances which led to a 4-year-old who's never been to the UK before, being in foster care for so long. But as you are no doubt aware, it is quite an extraordinary tale.
Could I interrupt, Ms Cooper, just to check? We read somewhere that the child moved to a paternal aunt,
Yes,
having been in foster care. Is that correct?
yes, my lord. He moved, I believe, either at the end of March or the beginning of April of this year, and he has remained there, as far as I am aware, ever since.
So that seems to have happened in the wake of the judge's main judgment.
Yes.
By agreement, or it just happened?
Well, I would say it just happened, my lord.
All right.
It
Anyhow,
was-
so to add to what you've told us, in fact, the child is now with an aunt and uncle
yes,
in London.
yes,
Oh, right.
Yes.
yes, my lord. The father's sister. This is a 3-jurisdiction case where the child who was originally born and who is a citizen of the United States of America was then moved to India and then brought to this jurisdiction in October of last year. The move from the USA to India at a very young age is the very subject of dispute. What is not in dispute is that since July 2017, the mother has not seen the child, and there has been no communication between the parents. The circumstances in which the move happened in July of 2017 were ruled on in the judgment, and the learned judge found that my client had consented not merely to a holiday, but had consented to a permanent move. The findings of fact made in relation to that issue, that first issue, are very much in dispute. Not least because whilst it is entirely accepted that there are many factual issues thrown up in the course of a 5-day trial where consent is an issue, there was a very key piece of evidence which was always a fundamental part of the mother's case, which was there was an email produced by her lawyers in the USA indicating that at the beginning of August 2017, so within 1 week of the contested move to India, she had asked for advice on abduction. Not on any other issue, but on abduction.
May I just interrupt you for a moment, Ms Cooper, just to get an idea of the order in which you're planning to deal with matters?
Yes,
You can take it we've read the judgment and
yes,
read around in other aspects of the case as well. Your grounds of appeal, as it were, put at their head the rather self-contained issue of comity,
yes,
and then move on to welfare and end up with your attack on the findings of fact. It does seem to us that logically attacks on findings of fact really, so to speak, come first and are likely to colour one's attitude to the other issues in any event. So I was really wondering whether you plan in your oral submissions to reverse the order of your skeleton.
by all means, my lord.
I think we would find that helpful.
Yes, absolutely.
Thank you.
Well, dealing therefore with the findings that were made by the learned judge, I would say at the outset that I entirely accept there was a lot of evidence. I reread through my notes as to the starting and the end times of the 5-day hearing that was conducted by CVP, with understandably some technical problems en route, which led to the loss of some, but obviously not all of the time. They were early mornings, late evenings, over the 5 days. And clearly within those 5 days, there was a large amount of evidence from both parents, plus the, what I shall term, supporting cast of 2 supporting witnesses on each side, plus the guardian. Included within those 5 days was time given for submission or submissions from 3 parties, albeit not judgment.
How long did the parents each give evidence?
Probably
Roughly?
about a day, my lord.
About a day each?
Yes, about a day each, possibly slightly more.
Thank you.
My lord, as you can well imagine, given that both parents were on CVP, my client was in New Jersey, the father was in HMP Wandsworth, and both of them required interpreters. There were some practical
Was this
issues on
interpretation, as it were, strict interpretation, or was this, as it were, assisted evidence giving, as one sometimes finds?
No, my lord, it was strict interpretation.
Thank you.
Certainly during their own evidence.
Yes.
I'm not sure quite what else was going on during everybody else's, but during their evidence, it was strict interpretation. My lord, I entirely appreciate that when challenging findings of fact, in standing where I am, it is a huge uphill battle. And I appreciate that no doubt it will be said that this judge had the opportunity to see and hear from the witnesses, and she was entitled as the trial judge to take the view that the mother was less than impressive as a witness. And it's quite clear that she did not accept what my client said about her asylum claim, about allegations of domestic violence, or about the circumstances in which the FBI came to know that the father was planning to travel to this jurisdiction. However, on the central issue that she had to decide, which was consent to a permanent move, in my submission, the judge did fall into error. She was clearly entitled to take a view about my client's general credibility. The view she took was not a rosy one, but there was other evidence that came from other sources. And in my submission, the judge has ignored that. The most important independent evidence is the email from my client's USA lawyers. The father never chose to challenge that email.
This is B202, is it?
Yes, my lord. It's a short email which says that the lawyers who she had been using had been consulted. She's been using them in relation to her immigration matters before then. I think she's gone to them in May. But
I'm sorry, I'm going to have need the page reference again.
Yes, my lord.
Which
It's-
bundle?
It's B202 of the core bundle, my lord.
Right at the very end.
No, B202.
B202.
B202, thank you. Oh. My bundle ends at 201, not very helpful. Oh no, wait a minute, sorry. No, yes, sorry, I've got it now, yeah, thank you. I see. So this is an email dated the 15th of January 2021, but referring to what happened on August the 3rd, 2017. Is that right?
Yes, my
Yeah,
lord.
yes, I got it. So it's just that one sentence.
Yes.
Your client had a consultation with the managing partner in regards to her child being abducted by the father.
Yes, my lord.
And possibly the following sentence.
Yes.
Yes.
Well, it's quite clear that thereafter there are other documents which I don't think it's going to be necessary for me to take your lordships to, that show that my client was desperately trying to get an appointment and trying to get her US lawyers to do something. But that is probably less important when considering the judgment than the fact that in August she went there. There is another piece of evidence which I do say forms a part of the puzzle, which is Mrs. Trigg, who was the expert from New Jersey, who was called at the last minute because the father changed his case and said that the mother didn't have rights of custody because of the order of May 2017. She was also asked just for a one-line comment in relation to whether there was a provision for any free legal services for abduction cases in the state of New Jersey, and she confirmed that there was not. Now, my client works as a cashier in Dunkin' Donuts, and I do say that her modest income was relevant to the issue as to how fast, therefore, she was able to progress her case for the return of the child to the USA. My lord, I did check within my position statement, which I submitted for the final hearing, as to whether I had made reference to this email, and it is clearly marked up within my position statement as being
Just
something...
before you go to that, can I ask this
Yes.
question? On the face of it, this is a waiver of privilege. So do we have disclosure of the underlying documents?
No, my lord. There were huge difficulties in obtaining anything from the US lawyers. One of the issues which occupied the beginning of the 5 days was the issue that my client had not complied with the previous directions, I believe given in December by Mr. Justice Mostyn, to disclose her immigration files. The US lawyers there was a meeting at which I was also present, but I don't give evidence in relation to it because my instructing solicitor provided an affidavit or a statement for the final hearing explaining that at that meeting the US solicitors had said they were not permitted under US domestic law to disclose any of the immigration documents. That is what was said at that meeting, and they did not do so.
Yes, but that's not the question, as I'm sure you appreciate. because we read that there was a consultation on August the 3rd, not
Yes.
about immigration, but about child abduction. So one presumes that the US lawyers would have a file note
Yes.
of that consultation, in respect of which privilege has been waived,
Yes.
and yet you tell us that the file note has nowhere been disclosed.
No, my lord. I'm afraid there was. They were very difficult to obtain any information from. I accept entirely, my lord, that they had not said to us that they were prevented from disclosing the family papers. But they never produced anything.
One problem we have with this email, of course, as I said, it's dated January 2021, so there's a real danger. It may be, as it were, the wording of it may be very influenced by hindsight and the knowledge that by that stage, abduction proceedings were on foot, there were arrest warrants out for the father and so on and so forth. So that's why, as my lord says, it would be really, to make any reliable findings about what happened at that meeting, one really would need to see the contemporary record of it.
My lord, what I will say is that after this email was produced both to the father and the guardian, they never suggested that they sought to challenge it, given that it had come from lawyers in the USA. If they had have said that they wished to challenge it, then no doubt we would have tried to push further in relation to the USA lawyers.
But it's not a question of them challenging. This is a hearsay statement by a US lawyer. No doubt they took the view, well, it's not worth very much. Why would they need to challenge it? Why were they not entitled to take the view that in the absence of disclosure of the underlying file note, its weight was such that not much needed to be said about it?
Well, my lord, with all due respect, in the context of an abduction case, an experienced lawyer reading that email, even a one-liner, in my submission, would understand that that was really quite an important piece of evidence coming, as it were, from a US lawyer in the context that the father said there was an agreement and the issue therefore being about consent, particularly given the timing. The father also knew that the mother had never previously sought, because that was her case, any type of family advice. She was only, this is the father's case of course, that the mother's whole motivation is around the issue of immigration. That is why she had previously gone to other immigration lawyers. As I understand it, the file was changed over in May 2017. Part of the mother's case is she never took any family law advice at the time of either the agreement, in inverted commas, or the order in 2017. So whilst I do entirely accept it would have been preferable to have obtained disclosure of the file, the fact of obtaining any family law advice in August 2017, in the absence of any family law advice ever having been taken by the mother in the USA, in my view, is significant.
Now, you were going to show us where in your submissions at the time
Yes, my
you
lord.
made this point. What's the reference to that?
It's in the supplementary
Yes.
court bundle, my lord, at D294.
Thank you. All right, so that paragraph 13 on that page.
Yes, my lord. And I reread my notes for the final submissions, and again, although we do not have a transcript of the final submissions, it was a point that I made.
Right. Now, you want to take us to the judgment to see what the judge made of it, or where the judge might have made something of it.
Yes, my lord.
Paragraph 32.
Yes. My lord, in my skeleton, I think I identify the paragraphs where the judge, yes, it was paragraph 32, and then it's mentioned in passing at paragraph 86. In the context of dismissing any argument in relation to acquiescence. The judge says at paragraph 86, however, if necessary, I accept that the father would not have established acquiescence since there was some evidence that the mother had contacted lawyers about abduction on the 3rd of August 2017. So whatever the limitations were of that email, the judge accepted it, as did the father.
Well, some evidence. It's carefully phrased.
Anyhow, your point is that if it was worth something in relation to acquiescence, it ought to have been dealt with in relation to consent.
My lord, yes, because it must put a different spin on it. And if the judge had come to the view that my client had consented, then she needed to explain why the mother, within a week, paying for the service herself from her Dunkin' Donuts income, went to go and see a family, not an immigration lawyer, to complain about abduction. I mean, either the mother had changed her mind within a week, or it rather sheds a different light on the events that had gone beforehand.
Now, you mention the mother changing her mind within a week. To what extent did that possible interpretation feature at the trial?
Not at all, my lord.
Right, so you didn't say it because that wasn't your case. The father didn't say it because that wasn't his case. The guardian didn't raise it as a differential possibility. And for that reason, no doubt it doesn't find its way into the judgment.
My lord, yes. I
Right.
suspect that
So
is the
how-
reality.
Well, how does that help you on an appeal?
Well,
I mean, I can quite see, sitting as where I do, that the facts might very easily have lent themselves to a suggestion that the mother did something dramatic and then repented of it very quickly. But how does that work
well, my
in the
lord,
context of an appeal if no party thought that possibility even worthy of mention?
well, my lord, I believe I cross-examined the father on it. So I did raise the issue.
I'm
as
sorry,
to-
I understood.
Yes, sorry.
hadn't been
well,
raised.
sorry, in relation to the... My lord, I'd understood you were referencing whether it was put to the mother.
No, I was really asking whether the possibility of a change of mind almost immediately on the mother's part, so that the father departed with consent, which would give him a Hague defence, but in welfare terms it might be an important feature
Yes,
if the mother had immediately changed her mind and the father had known about it.
yes.
So you're going to help us, are you, as to whether that possibility was mentioned, and if so, how?
Well, it wasn't put to the mother, to the best of my recollection, when I went through my notes of the father's cross-examination of the mother. I do not recollect, but obviously I may well be wrong or didn't keep a note, that was put to the mother by counsel for the father. But I have a note that I put it to the father as to why it was that there was an email indicating that she had sought family law advice.
Yes, but that was presumably in support of your case that he hadn't had consent in the first place.
Yes.
Yes, I'm not talking about the email being considered, but of course it must have been considered. Mm. But at the moment I'm understanding that, for no doubt reasons that seemed good to everybody at the time, nobody ran a case of immediate change of mind.
No, right. That's not my client's case. But I do say that if, given the existence of this email, that it, at the very least, it merited an explanation, my lord.
Okay, well, where in the submissions made in writing to the judge, for example, was it urged upon her that she ought to consider the possibility that, against the mother's evidence, she had in fact agreed at the time but changed her mind within days? That case wasn't put, was it?
No, my lord. Well, that wasn't the mother's case. I mean, the mother's case was always that she had not changed her mind.
Yes. Well, I'm only focusing on this because you told us a moment ago, either the mother didn't consent or she changed her mind within a week.
I say that, as it were, from the position of the learned judge writing her judgment in relation to how the judgment considered that issue.
Well, I can see that the mother and the father, for their own reasons, may not have wished to run that case. But the child was represented here. And that wasn't a case that, as I understand it, was explored on the child's behalf either.
Not to the best of my recollection, my lord.
Well, that's clear. Thank you.
Thank you. But I was very clear in my submissions that that email was important and that it shed light on what had happened beforehand. My case was not that it was a sudden change of mind. My case was that that was a further, later and independent piece of evidence to show there had been no consent.
To be sure, and we appreciate the importance you place on that, but can I just ask a slightly different question? Because my lord has adverted to two possibilities, and I just would like to ask if a third possibility was canvassed, and I suspect the answer is going to be no. Namely, that the nature of the discussion on the August the 3rd was to inquire whether it was open to her, the mother, to change her mind, having entered into the agreement.
My lord, you're right. There was no discussion about the detail of what was or wasn't discussed in August.
Because we don't have the file note.
Because we don't have the file note. No.
Have we finished on the file note of January 21 then? Have we finished on the lawyer's email?
My lord, save for just one legal issue I wish to raise, which is my learned friend, I believe the father, relied on cases of Carlisle and RBS and Cheng and Ung, and what I would say in relation to the law is that within Carlisle, a paragraph 21, if if I may just turn to that, which is at B261 of the authorities bundle. This is a Supreme Court case from 2015, and at paragraph 20 onwards, at B261, it sets out what the role of the appellate court should be. And within that, they summarise other cases. And if I could just refer you to the second paragraph down on page B262, where it says, Lord Reed summarised the relevant law in paragraph 67 of his judgment in Henderson in these terms. It follows that in the absence of some other identifiable error, such as without attempting an exhaustive account, a material error of law, the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence, an appellate court will interfere with the findings of fact made by a trial judge only if it's satisfied his decision cannot reasonably be explained or justified. And I say that in relation to this email, it fits into the category of a demonstrable failure to consider relevant evidence.
Well, I mean, the judge clearly did consider it in the sense she plainly had it in mind, because there are two references to that email in her judgment. I mean, isn't really the point that she evidently didn't attach any significant weight to it because, for the reasons we've just been going into, there was no contemporary record of what the advice consisted of?
Well,
just the reference to it in a short one paragraph in a letter written 4 years later.
my lord,
I mean, it's building really bricks without straw, isn't it, to try and build anything significant on such a slender foundation?
my lord, I have to accept it's a slender foundation, but I do say it is an important one in the context of these sorts of cases.
I suppose your point is we don't know what the judge thought about it.
No.
No. Well, perhaps we can infer not a lot, because if she had, she would have said something.
Yes.
But that's
Yes. I mean...
Right, well, but the next hurdle you face at the hands of Mr. Heifer is that although you acted commendably from your client's point of view in getting the appeal up and running without waiting for legal aid and so forth,
Yes.
this is the sort of point that might quite easily have been the subject of a proper request to the judge to say, what did you think about this? So that we...
My lord, I have carefully read the case that Mr. Heaver has added in his skeleton argument, and I have to put my hands up and say at the outset that I did not raise in terms with the judge as to whether she might like to comment further on this particular email. What I will say is that I was enthusiastic in drafting the grounds of appeal such that an identical set of grounds of appeal were appended to my position statement, which was sent to the judge at 4 o'clock the day before. Neither myself nor any other members of the bar invited the judge on the basis of that to, as it were, amplify her judgment. And the judge, I can only say that the judge didn't offer to.
So this is. I mean, if we call, I know you've helpfully grouped them into three, but there are a large number of paragraphs, and it's paragraph 7 of your grounds of appeal as presented to the judge at our page A17.
Yes.
Is this particular
Yes.
failed to explain
Yes.
point. So the airstrip was well prepared for you to take off it and say, would you please explain it, or for the judge to have landed and said, actually, this is the answer
Yes.
to that. But neither of those things happened.
No, I'm afraid they didn't, my lord, and I have to take the primary responsibility for that. It's not something that I will ever forget now, having read that case, that there was, I should have invited the judge in terms to have amplified her judgment. What I will say is that I conducted the hearing where I asked for permission to appeal. The judge was very clear. She considered all points had been dealt with. That is my note of what she said at that hearing, because I reread my note of that hearing as well. She said, I have dealt with all points. She clearly had read the grounds of appeal, and she was not giving permission in relation to those. I mean, I entirely accept that the primary responsibility was on me to invite her to amplify, but this was not a case where she wasn't very clear as to what I would be saying. And I did ensure that those grounds of appeal were served at 4 o'clock the day before.
Yep.
But I do accept I could have done it better, my lord. In relation to the other factual grounds, where I challenge findings of fact, I rely both on my original skeleton argument and on a short supplemental argument where I just added a further few points. Again, I have been frank that they should have been covered, those points in the original skeleton, but I'm afraid I ran out of time, and I wished, because I knew that there was an order for the child to get on a plane, to ensure that the Court of Appeal had something on the main points rather than miss the boat, as it were.
Would you mind, just for my note, you said that there was other evidence that the judge ignored, and you've dealt now fully with the August 3rd
Yes.
meeting. What in list form are the other pieces of evidence that you rely on?
The other pieces of evidence that I rely on are, I mean, I do rely on really what I've said in my grounds of appeal.
Yes, well, would you mind just giving us a list?
Yes,
So
no,
we've got them
absolutely.
ready
But
to hand.
yes. So from the grounds of appeal, paragraph 8,
Yes.
the judge really ignored the steps that the mother had taken, in fact, to push her US lawyers to
Right.
do something.
So the US litigation.
The US litigation.
Right, that's another point.
I mean, I thought perhaps the judge was a little unfair on the mother, given her circumstances. She did try to jolly along her USA lawyers.
Ms. Cooper, at the moment, if you wouldn't mind, could we just have a list of the points? Because
Yes.
It's helpful to know what the range is before we go into the depth of it.
Yes. My lord, the next point is in relation to what the father's sister said to a social worker in October of 2020.
Yes.
The next point is in relation to how the judge treated lies which she considered the mother had made.
No, I'm talking about evidence
Miss.
ignored
Yes.
by the judge on your case. The visit of the brother-in-law
Yes.
in August 2017.
Yes, I wouldn't say, my lord, that she had ignored it. She rejected it.
Well, did she reject it, or did she not deal with it? I know she said she didn't place any store by any of the other
Yes.
family members as factual witnesses. But I thought your complaint on this point was that we were left not knowing at the end of the judgment whether the brother-in-law had visited or not.
Well, my lord, that's right. I mean, it was a general rejection of all supporting witnesses without really examining the differences between them and why possibly some of the supporting witnesses she might have accepted their credibility and some of them she might not.
Are there any other points for the list?
Suitcases, my lord.
Yes.
The frequency with which the father changed jobs, having been in the USA for 9 years. The detail of what the other US lawyer actually said, so Ms Parek,
Yes.
and the September 2018 phone call by the father to the New Jersey court staff when he was told that the mother considered he had kidnapped the child.
Yes. All right. So that's the prospectus for that
Yes.
material. Now, what was made, if anything, during the case of the text messages that were sent on the day and day after, maybe 2 days after the departure from the States?
Well, the father was adamant that there was another side to those, but that he hadn't been able to produce them. And a part of my final submissions was to list the evidence that the father hadn't produced that the court might have been expecting him to. And that is the reason why within the judgment, my lord, the judge included a paragraph indicating that she felt sympathy with the father for not having collated the evidence.
Yes, but just in relation to the text messages,
Yes.
we have in the supplemental bundle at C144 and following a sequence of translated WhatsApp
Yes.
messages, which are not in order, of course, but starting, if you would, at C144, the translation of a message, date not given there. That's the father speaking to the mother. I want to talk about iron. Is that right?
My lord, that is my understanding, yes.
Right. Then we go on. Sorry. I'm looking, for example, at 138,
Yes.
in which it appears at first blush to be the mother speaking to
Yes.
the child through the father.
Yes.
On the day after, actually the very day of departure.
Yes.
Then the following day at 139, which the mother seems to be asking the father to let her see the child, quote, for once.
Yes. I think she hadn't seen the child since departure.
Well, departure on my note is the 27th of July.
Yes. I think she was
But
expecting...
she went to the airport.
Yes, but after then, I think she was expecting when they touched down. Because if one reverts back to C138, she's saying, video call me when Ian wakes up. I want to see Ian only once.
Well, my question to you now, we've just taken a very brief look at those, is I'm not aware that those featured in the judgment.
No, my lord.
Did they feature in the submissions to the judge?
I don't recollect that they did, my lord. Not
Did they?
in any great detail.
So it follows then that they can't have been very intensively explored in the evidence for the insight into which they give, at least to your client's psychology, on that day.
No, my lord. Oh. My learned friend has referred me. They are in the judgment, my lord. I apologise. Apparently there is paragraph 64 they're referred to.
My mistake.
Sorry.
64 of the judgment. So that's the small number of text messages which are not a complete record.
Yes.
You're entitled, I suppose, to make the point that that's a slender return from contemporaneous material of that sort.
Yes, my lord. And I would hope I'm also entitled to make the point that when the judge makes comments at paragraph 65, where I criticised him for not having produced various pieces of material, the judge said, on about line 6, the events in question, she says, however, on the father's case, the absence of contemporaneous evidence was unsurprising, since there was no issue at the time. The events in question took place almost 4 years ago. But stopping there, it was the father, somewhat oddly, it appeared to me, who produced the transcript of his conversation with a court official in the New Jersey court in September 2018, when he was told in terms, whatever might be the truth of the matter, that the mother was alleging kidnap. So by September 2018, it must have been the case that the father was put on notice that, to put it at its lowest, there might be an issue. And I do say that that should have impacted on how the judge considered what evidence the father did or didn't produce.
At all events, the traffic in communication between the parents ended with a phone call on the 29th of July, was it?
I believe so, my lord. It was the 29th or the 30th, and then there was no more. And the father accepted that he blocked the mother on social media.
All right.
But just to, so as I understand what the judge means about not a complete record of the relevant communications, am I right in understanding that what the mother has produced here is only her side of the dialogue, not the father's side of the dialogue? Is that correct?
My lord, I don't want to mislead the court. My recollection is what the mother said was that there wasn't another side of the dialogue, but that the father said that there was, but he hadn't been able to obtain it, if my memory serves me correctly. But no doubt Mr. Heffer and Mr. Gratian may be able to remember. That is my understanding of the
Well,
mother's evidence.
I'm a
There
bit
was
puzzled
nothing
because
more.
what one is interested in is not so much what the witnesses said, but what was evidenced by the underlying documents. Now, we can see from 144 that that's plainly WhatsApp. It's
Yes.
less clear from the other pages referred to whether they're WhatsApp or text messages. But either way, one would either have in the underlying documentation an exchange or a series of exchanges, or you would have an uninterrupted flow of messages going only one way. One ought to be able to tell from the disclosed documents which it is.
Well, my lord, this is my recollection is that it was the latter. It was an uninterrupted flow going one way because my client's case was there was no response.
Well, don't we see that? C142, for example, which is sort of Saturday, please let me speak to him, please let me speak to him one more time, or something of that sort, or once more. Saturday the 29th, there one has a page of texts which are all one way going back onto the previous page.
Yes, my lord.
So if these are genuine text messages, they're text messages going one way and not receiving a reply or not being received.
That was my client's case. The father said, oh, there were others, but I haven't been able to download them. I don't know whether I can't recollect whether the father was saying that they were off this phone, his responses, as it were, or off some other phone. But, my lord, I do agree with you. I mean, they look like a conventional list of WhatsApps that have not been responded to. Because that's what my client said. There
Well,
was no response.
Yeah. So as we see in the excerpts that we have, there's plainly no response,
Yes.
and there's no other excerpts to suggest that there were any responses. Is
No.
that right?
Yes.
Well, there is one message that appears to be from the father, which is
Yes.
the one that appears in original at C145 and in translation on the previous page,
Yes, my lord.
which is helpfully said to be on a Wednesday, but
My lord, I'm told that that's actually the paternal aunt and not the father.
all right. Thank you. So nothing from the father at all.
No, my lord.
Anyhow, just to, because I introduced this, I don't want to hold you up, but if any point's to be made about it, it's that there was little enough information about what was actually going on at the time, and the judge would have done well to have reached a conclusion, if she could, about what this all meant.
Yes, my lord. And I do say that it was relevant when considering the father's ability to collect material, which I accept by the time of his incarceration may have been compromised. But it was relevant.
All right. I'm sorry to interrupt you, but there's there's a number of different points that we're touching on here, and I just want to try and disentangle from it. You're making a point here about what the father did and didn't produce, and I think I've understood that. But then there's a separate question which my lord has asked you about, which is to the extent that there was material and the way in which it's then dealt with in the judgment. And you make the point, we have these WhatsApp messages and we've discussed them and we think we understand now what they are. And you make the point, which is fair so far as it goes, all the judge says is mother produced a small number, not a complete record. But then she goes on in the next sentence, no contemporaries evidence to support her assertion. Father repeatedly assured her he would marry her, or that the trip was a holiday, or that he was returning to the USA. Now, is it your case that these WhatsApp messages that we've just looked at undermine in any way what the judge said in that second sentence?
No, my lord.
Right. So what is the significance that you place upon these messages? I mean, my lord has pointed out that we see repeated use of the words "for once," and it's fair comment to say, well, the judge hasn't pondered what that might mean and what its significance might be. But do you suggest that helps your case?
Well, my lord, what I say is it supports my client's case because obviously credibility was an issue. She said, well, you've got to, one of the things she said was, the minute you touched down, that was it. Communication was over, and you didn't respond. The father said, oh no, I did, but you were rude to me, there was an argument, and then after that we ceased communicating. It's not only what the WhatsApps do show, it's what they don't show. They don't show, they certainly do not show what the father said, that my client had indeed consented. There's nothing in there, there's no mention in there, how is he fitting into his new home? There might have been, have you gone to look at a school? I mean, those sorts of things. There is nothing in there. What it shows is someone who, I mean, this was a very, very young child. He was 8 months old. It's just a loving mother saying, I'd like to see my child.
The issue, one of the issues the judge had to decide was, did the mother agree to the child going to India?
Yes.
To live permanently?
Yes.
But that's not the same as, did the mother agree never to have anything to do with the child ever again?
Yes.
As if this was some sort of adoption. Was it the father's case that the mother had agreed to wash her hands of the child and have nothing to do with the child again? Was that the father's case about the effect of the agreement and the court order?
I'm not sure it really was the father's case, my lord, because in fact, one of the criticisms made of my client during cross-examination by the father and in submissions was that she and her family had failed to take any active steps to see Ian during the 3 years. So I can only assume that it can't have been a part of the father's case that, as it were, there should be no contact in India from thence going forward.
Well, the reason I raise it is because consent is, to consent to whatever was agreed. And it's entirely different to consent to a child going to live somewhere else, and to consent to a child going to live somewhere else and you not having the ability to ever see or hear about the child again. And so this seems to be another issue that was either not run, or if it was run to any degree,
Well,
not ruled upon.
no, my lord, I would have to accept that. I mean, of course, coming back to what the mother's case was, the mother's case has always been she was duped. She may have a degree in microbiology, but she clearly doesn't have a lot of common sense when it came to interpreting what was going on between February and July 2017. I mean, on the father's own case, he accepted that their sexual relationship continued until the end. I mean, the mother said, in fact, she was pregnant again in May or June of 2017. But she miscarried. Now, whether her case on that was accepted, the father accepted in his evidence that their physical relationship continued. At the very least, one can say, well, it must have been really quite confusing for the mother. She's a mother with a newborn, first-time mother with a newborn in a strange country. her qualifications were, and one can see this from the way that the father ran his case and from what is included in the judgment, her qualifications and her intellect were effectively held against her. I mean, effectively, between the lines, what was being said was, come on, you're a clever woman, you must have known. But I'm afraid, on the mother's case, she didn't understand that this was the father's plan. She didn't join up the dots. She trusted him. If you trust somebody, you're not looking to see whether this might be a possibility. Because
what do you say to the proposition that the best evidence of what was or was not agreed is the custody agreement and the custody order?
Well, my lord, I have to say, in relation to the custody agreement, I mean, that issue was never pushed even by the father. I mean, there clearly was. There was a document and it was signed. But, interestingly enough, even the custody order didn't refer to the custody agreement. Now, we didn't have expert evidence on the effect of the custody agreement, but I would be surprised, given that the laws in New Jersey are, as I understand it, broadly similar to what we have in this jurisdiction, whether it was possible effectively to contract out of having, well, really any parental responsibility at all, and providing an agreement in terms that the child could be taken anywhere in the world. That would seem unlikely.
But there's two different questions, are there? There's a question of law as to whether, as you put it, one can contract out and conduct custody. But then there's the factual question, what actually did the parties agree? And why cannot parties agree between themselves to something that actually, maybe unbeknownst to them, the law doesn't permit?
Well, my lord, what my client's evidence was about the custody agreement, she accepts she signed it. What did she think she was signing? She thought she was signing some document that would be helpful in order to obtain a visa, an Indian visa, because as I have explained in my skeleton argument, India does not permit dual nationality. The child was and is a US citizen. So the child needed a visa to enter India. And that was the whole basis for it. In relation to the order, of course, the order, and these issues were not canvassed in detail, but no doubt, my lords, you will note when you look at the order and compare it to the agreement, the order was a great deal less generous. The order did not remove, as indeed Mrs. Trigg confirmed and the father then accepted, any rights of custody. The order was essentially for a residence order to the father with contact to be agreed. It was not even in relation to any out of state, let alone out of jurisdiction travel.
Can you remind me, I'm just searching for the date of the custody agreement.
My lord, I know it's March. I
8th of
can't
March.
find it at the travel agent in March, my lord. Let me just find the custody.
According to the judgment, it's the 8th of March.
8th of
Oh,
March,
great.
thank you very much.
Thank you, my lord.
So it was the custody agreement which contains the very uncompromising statement of paragraph 4 that the father can behave as if he's a single parent,
Yes.
is dated in March,
Yes.
that for 4.5 months after that they continue to live together.
Yes.
The mother continues to look after the child alongside the father. Indeed, they continue to pursue their own personal relationship. during
Yes.
those 4 months.
And my lord, may I also point out, as I pointed out to the judge, that of course the custody agreement was drafted so that it might appear to the outside world as if in fact they were living in different properties, when on the father's own case they weren't. You'll see right at the top, there's 2 different addresses. But again, my client was told, well, this is, you know, what's necessary to show we're separated so that we can have this visa. So she signed.
And the order, you point out, provides for contact as may be agreed.
Yes. And it says nothing about any removal, even from the state, which would have been necessary, let alone from the jurisdiction of the USA.
But anyhow, this may or may not be interesting, but was the case, I can't have consented because I would never have consented to a removal which involved my elimination from the child's life, run?
Well, my lord, I think the answer is no, it wasn't run, because the case was I didn't consent.
Not that my consent was vitiated by
No.
mistake or deception.
Well, yes, we do say it was vitiated by mistake or deception, but possibly not that mistake or deception. It wasn't conditional, but the case was not, I would have consented if I had had contact in India. That was not the case. The
No,
case
but
was...
I was only just... I understand that you said I never consented. He was going on a holiday.
Yes.
And the judge wouldn't have that.
Yes.
And she gave her reasons for not having that.
Yes.
But the next step in the road might have been, even if you don't accept the holiday evidence, I can't possibly be taken to have consented to a move to India, as a result of which I was eliminated from the child's life.
Yes.
But that case, as it were,
That...
was never
No.
put or considered by the judge.
No, my lord.
Okay.
My lord, would it be helpful if I deal in any further detail in relation to any of the other fact-finding issues?
Well, we need to bear in mind this case is listed for 1 day.
Yes,
Obviously,
my
there needs
lord.
to be time for everyone to
Absolutely.
have their say. We have your written submissions,
Yes.
and we've heard you at some length on, I suspect, to the points you perhaps put at the forefront of your shopping list, if I
Yes.
can put it in those rather crude terms.
Yes.
So maybe now is the time to move on.
My lord, yes. May I just check that there was... nothing else. My lord, yes. Which point would you like me to deal with now, my lord?
Well, if we move on, as far as I'm concerned, I think it's a matter for you to decide whether you deal with your other grounds of appeal in what's left. It's the issue of comity
Yes.
and the welfare issue.
Yes, my lord.
I mean, comity is a self-contained point. Perhaps you can deal with that fairly briefly and then move
Yes.
on to welfare.
I'm grateful, my lord. My lord, let me deal with the issue of comity. The comity issue arises not because I say that the English court should follow the letter of a court in New Jersey. I entirely accept, which is why it is termed comity and not enforcement, that of course matters are at large for the court in this jurisdiction. However, it is an unusual case where in the context of another system where it is known that the father had the right to appear, it is known he was put on notice of those hearings, they were not ex parte orders, and the proceedings are continuing, that the English court has not put more weight on what was going on in the USA. Now, on behalf of the mother, of course, I say that that weight should have extended to accepting that there should be a return order, because that is the order that was made in 2018. But in any event, there's very little said about the US proceedings. Now, the US court orders have all been helpfully put in one place in the core bundle.
Just before we get into the detail,
Yes.
am I right in understanding that precisely because the father didn't appear despite having had notice, the US court proceeded on the basis of the mother's case that this was abduction because the child had been taken for a holiday only and she had not consented to permanent removal?
My lord, I assume that that must be correct, because all parties saw the statement that my client put into the US court proceedings in 2018, and that was her case, yes. But this was the father's choice not to appear.
Understood. But can you help me as to this? Once the English court has found that the facts concerning consent are different to those upon which the US court proceeded, what weight is the English court supposed to give the US court's order?
Well, my lords, I certainly accept that that puts a more nuanced view in relation to it. But I do say that the US courts still carry weight, not least because this is a US citizen child, and of course the court, having found that the mother on the facts consented and having gone through that exercise, which I accept that the court in New Jersey did not, then finds itself in the position under the inherent jurisdiction of having to weigh up various different factors in relation to welfare. And
Isn't this the real point, Ms Cooper? Speaking for myself, I don't think that concept of comity adds anything. Obviously, the courts here hold the courts in New Jersey in high respect, but the American court offers two things. It offers can be seen as offering two things. One is a concept of the case, its understanding of the case, and the other is the services that it offers in order to make welfare-based decisions for the child. In this case, the view that the New Jersey court took of the case just happens, it's perfectly clear because it's recorded in both orders, that it's the 2-week holiday case which the judge was operating under, and that has been rejected on a lot of evidence.
yes.
In this court. So presuming that finding of this court, of the family court here or the High Court here, stands, then the comity as an abstract concept has very little to offer. However, there is the fact within the welfare case that one of the things that the judge might have wanted to take into account, and we'll see whether she did or didn't, is that the American court offers a service to the parties and the child, is there, has got ongoing proceedings, and would make decisions about the child's future, for example, contact with one parent or another. Whereas it's not so immediately obvious, at least so far, that the Indian jurisdiction offers the same degree of assurance.
No.
So is your fire not really on the second aspect of this, which is subsumed within welfare, rather than on abstract issues of comity, where this court has reached a different conclusion on the facts?
Well, my lord, when I'm offered an open door, I will of course walk through it, and I accept that that is a stronger point, given that clearly this court made findings of fact which the New Jersey court could not do because the father chose not to engage. But the father's conscious choice not to engage in those proceedings, again, is absent from the tone of the judgment. My lord, I do certainly accept, and it was one of the points I made, that of course, if the child is returned to the USA, the father will have complete access, as he already has, to the USA proceedings. There is no stigma on the mother of being an unmarried mother, which is referred to at various points, in particular within, I believe it's within the Guardian's report. And because the mother said to the Guardian that she was concerned about utilising the Indian system. I mean, if the courts in New Jersey take the view that effectively, if the father makes an application for leave to remove from New Jersey to India, then that is something that, of course, is open to him. That rather moves us into the whole issue of the father's current position. We are all waiting for the judgment in the extradition proceedings, a judgment which is due out on Thursday. That is the understanding of the bar.
Do we know who has heard that case?
I assume it's a district judge. I know it was being heard at Westminster Magistrates Court, my lord, but I'm afraid I don't know who.
Right, so it was heard in May, came before the court again on the 10th of June.
Yes.
You tell us.
Yes, my
and
lord.
Judgment this week.
My lord, yes. I think it wasn't heard in May because the father was unwell and it had to be adjourned.
Right, so it only came before the court for a one-day hearing on the 10th of June?
That is my understanding, my lord, but it may be that Mr. Heffer has further details on that, but we are all of the understanding that whatever the hearing was, there will be judgment on the 24th of June. And in the meantime, the father does not have bail and is still in custody.
And presumably, at the extradition hearing, the court will have been made aware of the judgment in the present case.
Yes. Yes, there was an order that could be disclosed, I believe, to the CPS. That order was made very swiftly because the father relied on it in a renewed application for bail. So with absolute certainty, they have the judgment in this case. And in fact, I understand that the father asked the extradition judge to delay judgment until after the hearing of this case, because he wished to be present during this hearing and was worried that he would be extradited beforehand. But in any event, the hearing was delayed and the judgment, we are told, is on Thursday. My Lord, should I move on to welfare issues, because I am conscious of the time?
Yes, if that fits in with your plan.
I'm grateful. I agree that the issue of comity it is a difficult one, but I do say that something more should have been said about this in the judgment.
Well, again, plainly the judge had the New Jersey proceedings well in mind. She goes out of her way to refer to them at a number of places in the judgment, and indeed she refers to the order which had been made just a couple of days before she handed down her own judgment.
My Lord, yes, but...
But, I mean, given the obvious fact that, as my Lord has said, the New Jersey proceedings were all based on the untested assertions of your client, inevitably they're only going to cut relatively little ice with a court which has heard the evidence of both sides tested in cross-examination over a hearing that lasted for 5 days.
My Lord, I entirely accept that, and that's absolutely right. But there is a further issue as to why it is that the father chose not to participate in those proceedings, and what impact that might have had on the court's overall assessment of his position and his credibility. Because
well, I'm interested in the way you put that, because it makes the point a little more clearly than you did earlier, and I'm grateful, therefore. But that way of putting it rather suggests that this is an additional criticism of the judge when it comes to her fact-finding exercise, rather than with what she should have done once she found the facts that she did.
My Lord, I take on board in its entirety your comments. Yes.
Right. Thank you.
I will move to welfare. In my submission, the judge, unfortunately, was not clear in relation to how she was dealing with this child's welfare, having decided that the mother had consented. In addition to the points that I have made in my two skeleton arguments, I would just add as follows, that in the judgment, if I can take you to A73, having already decided that the mother had consented, the judge then goes on to deal with issues under Article 12, settlement under the Hague Convention. Now, whilst I entirely accept that it was agreed by myself and counsel for the Guardian, as it were, that ab initio, this was one of the relevant issues that the judge should decide, I do say that by the time that she had in fact decided that the mother had consented, that this issue, frankly, should have fallen away. And unfortunately, what appears to have happened is that because the judge has gone on to consider the issue of settlement, that has possibly clouded the issues in relation to welfare. Because at the point when the court decided that the mother had consented, the test then became welfare. There was no settlement issue. I mean, the judge might have considered that some of the cases might have been relevant, but really the welfare test was now different. This wasn't a settlement by the back door. This was a welfare test under the inherent jurisdiction of the court.
Well, looking with a focus firstly on the mother's Hague Convention summons, which was the lead application. The existence of consent gave the judge a discretion not to return. The existence of settlement gave the judge a discretion not to return. Did it not?
Well,
but the point you make is having found consent, there wasn't any need, strictly speaking, to address Article 12.
yes.
Although no doubt it's helpful for every judge to deal with the main issues so that one knows where they've got to in case they were wrong about the first one.
My lord, yes. I'm not going to criticise the judge in terms for having addressed Article 12. What I say is I think it may have clouded the real issue that the judge had then got to.
Right. Well, this is a structural matter, and it is complicated where you're dealing with a three-country
Yes.
case, as you've already said. But whether one calls it settlement or the fact that India is home to the child doesn't really matter, because in the end, in the welfare decision, it's got to be dealt with for what it is, not for the particular label, surely.
Well, my lord, with all due respect, in my submission, that is where some of the errors have arisen, because the issues in relation to settlement are not the same as the full panoply of issues that should be considered on welfare, in particular issues concerning contact going forward and access to overseas legal systems. It was not clear to me, whilst I appreciate that some judges might have considered those issues under settlement, that didn't appear to be the case in relation to how this judgment was dealt with. But when the judge came to consider settlement in its Article 12 sense, she considered it on a narrow basis, namely, was this the place that if you had asked the child, where do you consider home effectively, he would have said yes. And that has to be accepted. It's where he's lived for the last 3 years. But actually on a welfare analysis and looking at the welfare checklist, which is what the Supreme Court says should be, by analogy, imported into this decision on welfare under the inherent jurisdiction, of course, there must be other factors. In particular, as my lord has already pointed out, contact with the left behind parent.
Right. Well, I'm not quite sure to the extent to which there's any real issue arising about this. The judge did well to deal with the question of settlement because it was on the list of things she was asked to deal with. She didn't explicitly observe that she didn't need to deal with it,
No.
but her findings about it obviously fed into her welfare consideration afterwards. So would it be more profitable in the time remaining to you if we were to identify what were the key welfare features of the situation
Yes,
facing the child
yes.
at the point in time that the judge made her decision, and then see the extent to which the judge actually dealt with those or didn't deal with those matters? It may be helpful, since you draw attention to the checklist, to see what checklist features were or were not
Yes, my lord.
addressed.
Yes. Can I take you first to A80, please? At paragraph 109 and 110, the judge proceeds on the basis he needs to return to his home. He will be cared for by his paternal grandparents and his father in due course. Just stopping there, that was in the context of there having been no judgment on the extradition proceedings, and therefore it being a complete unknown as to whether the father will or will not be involved in Iron's life. Paragraph 110 makes it clear that the judge understood Iron needed to have a relationship with his mother. When one considers the Guardian's report, which I wish to take you to shortly, the Guardian was quite clear about a number of factors. First of all, the best contact that Iron has been having is with both of his parents, interestingly enough, the mother as well as the father, not with the grandparents. That is at paragraph 18 of the Guardian's report, which is at B189. B192, the Guardian comments that the father was dismissive in relation to the absence of the mother. B195, paragraph 39, she commented about the lack of solid attachment to the paternal grandparents. B197, paragraph 44, the Guardian commented as to the grandparents' lack of support or contact. And B198, paragraph 47, she said she thought the mother would promote contact if Iron were living with her, contact obviously to the father. And B199, paragraph 50, the Guardian says she wasn't confident in the grandparents. Now that was the evidence from the Guardian, so the most independent evidence about those relationships, those key relationships that are going to form the backbone of any welfare decision, taking into account the welfare checklist. Now, those pieces of evidence had to be considered in the light of the fact that there is no certainty that the father will be returning to India within the foreseeable future. It is unknown. And in my submission, given what the Guardian's evidence was, that this child's primary attachment was not to the grandparents, it was to the father, that it would be a very unusual welfare outcome for Ian to be living in India with neither of his parents, which is a real possibility in this case.
And hence, as I understand it, you say consideration of welfare should have been deferred until after the result of the extradition decision was known.
Well,
but what do you say to the prospect of an appeal, and maybe a further appeal? I mean, the extradition proceedings could, for all we know, drag on for years, couldn't they?
well, my lord, obviously I have to accept that the father has a right to appeal his extradition. That must be right.
But the requesting state may be able to appeal as well.
Yes, yes. The requesting state no doubt has got the right to appeal, I assume, my lord, in relation to the extradition matter, but that still raises the issue that as far as this child's welfare is concerned, the father won't be in India. Wherever he will be, he won't be in India.
I mean, if the child is returned to India, which is of course what the judge has decided, I mean, then his welfare will be a matter for the Indian courts to deal with, and presumably applications could be made there just as they could be made here for a change in the status quo, once it has become clear what the likely timescale of the extradition proceedings is. I mean, obviously depending on how they go and what rights of appeal, if any, are exercised.
Well, my lord, there was no expert evidence in relation to the timings within the resolution of any issues in the Indian courts, nor how they might treat my client, who is an unmarried single mother. Certainly, my client's comments to the Guardian were that she didn't consider that she would be treated fairly by the Indian courts, and interestingly enough, the paternal grandfather agreed with me in cross-examination when I put it to him that she had brought great shame on the family by being an unmarried mother, and he certainly agreed with that. So it is a huge unknown, my lord, and that is what I say is the advantage of a return to the USA, because if the child is returned to the USA and the father is not incarcerated, he has got complete access to the USA courts to make what would be the equivalent of an application for leave to remove to India.
Now, you've just touched on what seems to be an important point, and therefore I think we need to be clear as to exactly what your case was below. Was it your client's case before the judge that in the event that the judge came to consider welfare under the inherent jurisdiction, that there should be no return to India because your client would not get justice from the Indian courts? Was that her case? And if so, what evidence was relied upon in support of that case?
My lord, I don't think it was a major plank in my case, but I do believe that I did say something to that effect in submissions, but I have to accept I didn't have any expert evidence along those lines. My client had made, you will see when you reread the Guardian's report, that my client makes a similar comment. Interestingly enough, the father also brought proceedings in the Indian court, and he brought those proceedings when he knew that the US proceedings were on foot. And what we have from the father in relation to Indian proceedings is an application. His application seems never to have been determined.
Well, it was allocated to a registry of some kind or other.
Yes. And then I think that the father withdrew it. I don't think it was ever served on my client, but it probably matters not. But my understanding is that there are even more serious delays in the Indian system than in others.
But if it was your client's case that it was a relevant consideration on welfare that she wouldn't get justice from the Indian courts, was it not incumbent on her to produce some evidence to support that?
Well, my lord, that might have been rather difficult evidence to have been obtained as to generic evidence as to how the Indian courts were going to treat single mothers who've been away from their children for 3 years.
You see, you raised the question of comity. But comity is something that applies with regard to the Indian courts as much as it applies with regard to the US courts. And the fact that there may be a societal prejudice amongst certain sections of society in India doesn't necessarily mean that that prejudice is shared by the court system.
My lord, I accept that it doesn't necessarily mean that the prejudice is shared by the court system, and I revert to my previous comment is that it would be very difficult, therefore, to find evidence of that one way or the other as to whether the courts in India are or are not prejudiced. I mean, the sort of evidence that this court would be looking for would presumably be hard data rather than anecdotal. It would be very difficult. in relation to comity, in my submission, that doesn't arise because there is no order from the Indian courts.
Right, so then there's two different points, aren't there? One is the point that we've just been discussing, which is whether we should make any assumptions whatsoever about what the Indian court's approach to the case would be in the absence of evidence. But then there's the different point which you've just raised, which is, but there is no court order and no arrangements for any court order. And that's a point that doesn't depend upon any aspersions about the Indian courts, does it?
No, my lord, it doesn't. I
Right.
mean, there are no current proceedings in India.
So maybe that's what we should be focusing on.
Can we do that by looking at the orders that the judge made? The order of the 26th of March was made on the day in which judgment was handed down.
Yes, my lord.
And as we know, a further hearing was fixed by paragraph 7. I'm looking at the moment at page A42.
Thank you.
Where there was going to be a hearing at 9 in the morning to deal with 4 issues, which included travel plans and contact arrangements.
Yes.
So, although sometimes particular issues get lost in the maelstrom of a hearing which is meant to be covering multiple topics, by now these issues had broken cover.
Yes.
We then go to the order of the 9th of April, and we find at page A47, paragraph 19, that what happens is that there is specified contact prior to departure, but nothing at all said after that.
No, my lord.
Now, were there written submissions made for the hearing on the 9th of April?
Yes, my lord.
Right. What, from your point of view, was said about what should be done about ongoing contact?
Well, at the present juncture, my client is obviously not in India. I can't recollect what was said in relation to whether indirect contact should continue or not. It may have been included in my position statement, my lord. I'm afraid I cannot recollect.
Do we have your position statement for that?
Can I just...
Thank you.
Thank you.
Well, I know we have your final submissions for the main hearing.
Yes. No, I did have to do... Oh, right. My lord, what I said was, as to contact, the mother invites that this remain at the current level, daily remote contact, and that the father have daily remote contact, providing this can be facilitated by HMP Wandsworth. The mother would request that this issue of contact be revisited following a decision from the upper court. Because I was
Yes.
asking that the... Yes, sorry. That the Court of Appeal...
Right. So, are you talking about a decision of in the extradition proceedings or of this court?
Of this court, my lord.
But
I did not address head-on as to what should happen, as it were, if there was to be a return to India, and in terms what contact should be agreed. The judgment had already made it clear, and it was known within the bar that there was no mechanism, well, save by obtaining some type of mirror order, but there was no international convention, if I can put it that way, by which an English judge could make an order.
No, but there's no reason at all why, if you've got a situation described at the end of the judgment, whereby the father is saying there should be contact with the mother is saying it, and so the grandparents. There's no reason at all why one would expect they couldn't obtain an order from the local court in India reflecting that agreement. But that doesn't seem to have been an issue that was surfaced either.
Well, my lord, I'm not sure I entirely agree. What
is it that you don't agree about?
That the issue itself wasn't canvassed. It was canvassed with the judge that it would be extremely difficult for the mother to obtain any contact order. There was a complete absence, though, of expert evidence in relation to that one way or the other. And I certainly did say in my final submissions that there was no mechanism for enforcing, and I also reinforced the point that the grandparents' own evidence had been equivocal, to say the least, as to whether or not they would or wouldn't support any such contact. So the mother's case was, if you return Ian to India, whatever you may hope for, judge, in England, it's not going to happen over there.
Right. At the bottom of page A47, the judge dismissed a number of your applications.
Yes.
Which include an application to adjourn to await the outcome of the welfare proceedings.
Yes.
Extradition proceedings.
Sorry,
Yes.
misread. I mean, really, Ms Cooper, it increasingly seems as if your client, who was found not to be telling the truth, put all their eggs in one basket. And when the axe then fell, at that point, the only plan B that you put forward was adjourned to await the outcome of the extradition proceedings.
Well, my lord, one of the difficulties that there was with the case is that the Guardian's report only came in on the 11th of March. The trial started on the 15th. Now, the Guardian's report
was binary, yes.
Yes, it was
All
essentially
right.
a winner takes all.
Yes, all right.
So,
I mean, I wasn't putting this as a point of criticism.
no. But
It's just that we've spent the last hour or more dealing with points that weren't really dealt with.
Yes. Well, my lord, I should also emphasise, at the outset of the final hearing, I applied for it to be dealt with as a split hearing. I applied for that hearing to be dealt with as a fact-finding hearing.
Was there a formal ruling on that?
Yes, there was.
And is that one of your grounds of appeal?
Yes.
Which one is it?
Well,
Paragraph 2. Ground
thank
2.
you.
Failed to adjourn.
Yes.
Well, if there was a formal ruling, I mean, obviously we need to see that, don't we? I mean, if we're to, we can't possibly rule on that question without seeing how the judge dealt with it.
Well, my lord, the way that the judge dealt with it was that, I think what in effect happened was that she noted that I had asked this. She, as it were, parked the issue and sort of saw how we would get on during the week. And then I renewed my application, which I have no doubt I would have done on the Friday as part of my final submissions. And then it was dealt with. Well, I mean, there was a judgment, and she went on to deal with welfare.
So that seems to suggest that there was, in fact, no formal ruling on your application.
Well, my lord, I think I entirely take the point. I need to reread my notes as to what happened at the beginning of the hearing. I have copies of my notes.
I'm not sure this is quite the moment to be doing
My
this
Lord.
exercise.
Yes.
But can we now address the situation which presently exists, which is that a decision has been taken,
Yes.
and you have, I think again by informal route, asked this court whether it wants to continue with hearing the appeal in the face of the decision that is awaited. What is your position with regard to that?
My Lord, we informed your lordships when we came to know that the judgment would be handed down on the 24th of June. We do say that you should certainly wait until the 24th of June to see what that judgment is, albeit I entirely accept your lordship's point that there may well be appeals. I know not.
But at that point, anything arising from the Court at Westminster could only be considered by us if it was admitted as new evidence.
Yes.
So there would have to be a process by which that took place. I mean, I suppose your case on that is that if the father is sent to America, it heightens the unusual nature of the judge's return order to India.
Yes.
And if the father returns to India, well, then it rather reduces
Yes, I have to accept that.
the
Yes.
firepower that you can deploy.
Yes.
But I mean, on the face of it, our primary role is, indeed our only role, is to hear an appeal against the judge's own order, which was made in the position we are today of not knowing the outcome of the extradition proceedings.
My Lord, I accept that.
So, I mean, to go beyond that and look at the position as it is later in this week, as my Lord has said, I mean, would require applications for the admission of fresh evidence and no doubt a timetable of some kind for rapid submissions or whatever is appropriate. I mean, none of us can foresee what the position will look like when the ruling has been handed down.
And my Lord, equally, I entirely accept that, your lordships may consider that there is no purpose in awaiting that judgment or indeed considering that judgment in any event because of the right of appeal of both parties.
Well, that's a separate point. And I mean, it seems unlikely, to put it mildly, that both sides would immediately make it clear they have no intention of appealing whatever the decision is.
That may well be right. But currently, as the judge understood the position, the father, they said there was a real possibility of extradition to the USA, which would therefore leave an unusual situation, to put it mildly, where the child would be living perhaps for 10 or 15 years in India, and both parents would be in the USA, in the context where the guardian has found that the child's primary attachment is with the father and not with the grandparents. I mean, it might have been different.
I mean, I follow all that. But I mean, if that is the kind of timescale we may be contemplating, then that should, on the face of it, allow plenty of time for an application to be made to the courts in India. And at the moment, we have no evidence whatever to suggest that they would not deal with that application entirely properly and fairly to your client. I mean, we certainly can't make assumptions based on nothing other than sort of prejudice or whatever we might have happened to, ideas we might happen to have at the back of our minds about how the court system, how the family courts in India operate. It's a matter that has to be established by evidence if if it is to gain any traction in this court. And what I can, I think, say, if it helps you, is that, I mean, on any view, I think we're not going to announce our decision on this case today.
No.
We will want to take time to consider the position. And given the imminence of the ruling on Thursday, I think subject to discussion with counsel, we will want to allow a short opportunity for any submissions as to new evidence or applications that might be made in the light of that decision. So to give an opportunity for the parties to consider where they are when the ruling has been delivered. And that's a matter we can discuss perhaps at the end of the hearing. But further than that, it's difficult to see how much further we can go, bearing in mind that the primary focus has to be whether the judge was right to make the decision she did on the basis of the evidence as it stood before her.
Yes, my lord. My lord, those are the points I wished to make. Are there any other issues you wish me to deal with?
Anything else, Peter?
Can I just raise one matter? There was a whole side issue as to how it was that the father came to England.
Yes.
And the role of a Mr. TP in all of that.
Yes.
That appears to have pretty much vanished from all trace in the documents which we've been given. It's not mentioned in the judgment.
I think it might. Well, my lord, I have to say, I can't recollect whether it is or it isn't in the.
Well, there's a discussion about how the FBI came to
Yes.
know and so forth, but I don't think there's any discussion about the tickets and the free holiday
No.
and so forth. That it was the father's case that the mother had set a trap for him.
Yes.
But the judge simply doesn't touch that point.
No. I can't recollect, and no doubt my learned friend will correct me, but possibly the judge says something about that in relation to the mother's credibility, because what happened was she had not accepted that initially. She, that is where the FBI had the details of the ticket.
Yes, but that's a different individual
Yeah.
who's got a different name. As to anyhow, I mean, there it is. It's simply a matter which was not
No.
ruled upon. Okay. That was what I wanted to ask them.
Thank you very much. No, nothing. I think nothing further from
Thank you very much.
either of us. So thank you very much,
Thank you.
Ms. Cooper. So, Mr. Heifer, I think you're next.
Yes, may it please your lordships. I was going to start by, forgive me, by making some obvious points that, of course, your lordships are at considerable disadvantage by having no transcript of the evidence.
Absolutely.
And when one just steps back for a moment, and I'm grateful to my learned friend for pointing out the length of the days, 5 days of fairly solid evidence on fact meant that the judge was privy to a lot more material than your lordships are. And my learned friend has obviously done her best to recollect what was asked and what was said in response, but inevitably that's, as it were, a recollection, and also it is a selection. And the Deputy High Court judge had the benefit of those 5 days of seeing both parents cross-examined, I would say, fairly robustly on some very difficult issues. And of course, one then gleans from how they deal with the questions and how they respond and the manner they give their responses and how they may or may not be evasive or frank as to what weight to attach to what is said by whom. And of course, then the supporting cast can also shed light. And the guardian inevitably, at the end of the process, adds considerably to the picture, particularly on welfare. And the Lords will come to that in turn, because the trial judge lent heavily and in my submission appropriately upon the Guardian's analysis on welfare. And she had that distinct advantage of hearing from the Guardian. My Lord, at a canter, perhaps I can take Comity very quickly, because in my submission, it's not an attractive argument to suggest that the trial judge didn't deal appropriately with that as an issue, because the way that she was to deal with the trial was in fact agreed at the outset. And one has that at A51. This is the judgment now I'm referring to, paragraph 10, where we find, in fact, I would humbly suggest a very well-ordered judgment with headings and an easy flow to follow, an order that is apparent whereby paragraph 10, the issues were helpfully identified by the Guardian, learned from Mr. Gratian did that in his opening note, and adopted by the mother. And what one sees then, A through to G, is what the judge goes on to do. What one doesn't see, with respect to the learned friend for the mother, is A, one has to adjourn off, or A, at first instance, the court must follow what the New Jersey Superior Court has said, because that was not how this was presented to the judge. It was as per the issues A through to G. And that is what the judge then proceeded to do. Of course, she was well aware of the US orders. She refers to them through her judgment. She refers to them on the face of her orders. There's no suggestion she did anything but accord respect and due consideration to those orders. And indeed, the order that she made provided for her order to be sent to, I think it was Judge Brown. And Lord, forgive me, I don't know who sent it and whether it went, but certainly it was in the judge's mind that it ought to go, so that Judge Brown...
I certainly read a reference somewhere to that point having been raised with the judge and
yes,
her having done that.
Absolutely. And then, of course, your lordships have the obvious point that Judge Brown had the mother's case, and we had an affidavit at some point produced from the mother that set out her case, that she had only ever agreed for a holiday and so forth. That was it. And of course, our Deputy High Court judge had 700 pages of evidence, 5 days of oral evidence from 4, 5, 6, 7 witnesses, lengthy submissions, and determined the matter on an entirely different basis to the summary decision that had been made by Judge Brown. And the learned friend doesn't even begin to argue that she was not entitled to do that, because, as I cantered through the issues, it was accepted by my learned friend right from the start that she was entitled to do that. There was no submission made on behalf of the mother that wherever the judge ended up at the end of her 5-day trial, what wasn't open to her was arriving at a decision different from the New Jersey court. Because the mother, of course, entertained the prospect, going through the issues 10A through to G, that one could end up with...
The submission being made is not that it wasn't open to the judge to do something different. Rather, the submission is that the judge ought to have taken the US court's orders into account in her welfare analysis, and certainly to a greater extent than she did.
Yes, indeed, my Lord, and my submission on that is that she did take them into account, that she refers to them, she attaches weight to them, but at the same time, she's acutely conscious of what the parties are asking her to do, and what she does do, which is to try the case in accordance with the Hague Convention application that the mother is pursuing, in accordance with the domestic law of the court that applied to her, upon the evidence that she was hearing. And that's what she does.
At paragraph 11, she explicitly said that her findings recognised the child's a US citizen and that the New Jersey court was seized in May 2017 in relation to his custody.
Lord, if I might move on perhaps to the nub of my learned friend's appeal, and that is the validity of the findings that the Deputy High Court judge made. In my submission, she conducted a fair and just hearing. There is no mistake at law that she conducted an evaluation of the evidence that was open to her, and she made findings that were open to her, that she's presented a clear and well-reasoned judgment, she's explained the basis of the findings that she's made and the conclusions that she reached, that the detail and analysis is evident within the 30-odd pages that we have, and the obvious points I make in my skeleton argument that I repeat, that she had the considerable advantage of hearing directly from the parties, albeit by remote link, no points being made about that, in order to, as it were, judge the emphasis and weight and nuances that one can do from hearing from parties. And that thereby this court will accord the respect due a trial judge who has that advantage. Even more so in this case, where the findings turned on credibility, where the parents were saying very different things. They couldn't both be right. One was being untruthful, the other, no doubt, truthful. And the trial judge had to determine which.
It's not the kind of case where you might end up saying both sides were mistaken in their recollections or what allowed themselves to be persuaded of such and such a case. It was a pretty stark choice. One side, at least, is frankly putting forward a dishonest and untruthful case. And
the trial judge absolutely identifies that at the core of her judgment, that credibility is at the root of this. And it's at A64, it's almost topped and tailed in her judgment, at paragraph 60, with the subheading Assessment of the Evidence, where she leads, the factual dispute depends to a large degree on which parent is telling the truth. And then further on at the conclusion, as it were, of this central section, A71, paragraph 83, both sides alleged that the other was deliberately lying. And it's as your lordship says, one's the liar and the other's the truthful witness. And she was tasked with considering that. Possible that she could have, as it were, sat on the fence and not been able to decide. But in my submission, by way of a fairly meticulous process, because one has a very reasoned approach, which I'll come to in a moment, she is able to make a clear finding on credibility and choose between the parents. Lord, I don't intend to run through the law set out in my skeleton argument, save to make this broad point, that it was not for this judge, she need not set out slavishly every aspect of the case that she heard, every point of evidence and every argument put. We would be troubled with a judgment going to hundreds of pages if that were to be the case. And it is, as it were, my learned friend's task, it seemed, to try and light upon parts of the evidence and the material that she had that she didn't cover in the detail that the appellant now says she should. Well, that was not her task. And when your lordship stand back and read the judgment as a whole, the issue is to see whether there is sufficient, as it were, detail and analysis, whereby the judgment as a whole stands up. And in my submission, it does that.
Let me test this with you, Mr. Heaper. You've taken us to A65, and it's at this point the judge analytically approaches her reasons for preferring your client's case to the mother's. And she starts off with not supported by the contemporaneous evidence, reference to the mother's case. And then she goes on, paragraph 62 and so forth.
Yes.
Now, you'll have heard Ms Cooper speaking about two aspects of this, one of which I raised with her, which was the text messages on the day and days after departure from the mother's side. And then there's the visit to the lawyer a few days later. Now, as to that, in this section at paragraph 64, we've seen the judge referred to a small number of text messages. Is it not surprising that she doesn't ask herself what they tell?
Lord, I would respectfully suggest she does, in that she looks to see whether the mother who, on her case, was raising complaint against the father of abduction almost immediately, and thereby instructing lawyers to present a case against the father, why it was that she wasn't, as it were, making complaint to the father.
Well, because by that stage, I mean, the sequence of events as the mother describes it is you're going temporarily, and then we have a bust-up on the telephone on the 29th or whenever it was, and I go to see a lawyer. That's her case. And so the text messages on the day of departure and the day afterwards, I want to see him, let me speak to him for once, wouldn't be expected to say, what are you doing removing here? Because on her case, she knew why he was going. She was missing him. So how does that, and the fact that she appears to have gone to a lawyer a week later, a week after the departure, how does that fit with your client's case? That this was a effectively mother who'd been eliminated from the child's life.
Yes. This was an aspect of the case that the judge did deal with.
She did deal with it.
She did deal with it.
All right.
But it, in these terms, if your lordship will forgive me, I'll, as it were, run up to it, because it's an unusual point that struck her. In fact, she described it as as extraordinary was the word she used. But firstly, the father's response to those texts is in his statement at B160, which I'm hoping is the core bundle. I think that must be right.
Yes.
Which is his paragraph 41.
Thank you.
Because your lordships have in mind that he's now in HMP Wandsworth. He's struggling to access anything and obtain the evidence that he says he may or may not be able to get. The judge was sympathetic to this. And secondly, he's saying, I certainly not until September 2018 did I think that this mother would be raising anything like this. But his case is at paragraph 41, where he's challenging the mother to produce at least the phone records. He says he was using his father's phone, and that there were WhatsApp messages across a great span of these key days, and show us the call history. And all one has is what your lordship has identified from the mother. On the father's case, a careful selection. And thereby, the trial judge queries why the mother's selection doesn't at least show the case or speak to the case that she's putting at some point. Now,
and the judge seems to have accepted that what was produced was not a complete record.
Indeed. She preferred the father's case on this, taking the evidence of the texts and hearing from both parents who were cross-examined, and your lordships don't have the transcript of the evidence nor the advantage of the judge, having had them both tested as to who was saying what by what medium and producing what then. This judge did, and thereby she believed the father on this rather than the mother. My lord, the point about the elimination of the mother, that is dealt with at A68, I think it's paragraph 72. And as your lordships turn to it, it's this about the case, if I can put it in some context. The maternal and paternal families living in Gujarat lived, I think it was something like 20 or 30 kilometres apart. It was put that it was a 30-minute drive from one village to the next. That in fact that they knew each other. There was an occasion when the maternal grandmother saw at a family wedding and decided to step away from any meeting. And what struck the judge as extraordinary, her word in the third line of that paragraph, was that on the mother's case, she yearned for her little boy, missed him desperately. He had been abducted and kidnapped, but yet she knew exactly where he was. She had the address, she had the contact details. In fact, the father's case was she had his number. Her family knew his family. They were the distance apart. And certainly from August 2017, which is the point the learned friend makes about the paternal uncle that I can deal with in a moment, right the way to date, they made no effort whatsoever to find out anything about the boy, ask how he was, send any messages, send any news of themselves, or request from the paternal family any news back. No gifts, no cards.
So what was on your client's case? What was the basis upon which he took the child to India permanently?
That the mother wanted to get on with her life.
Right. So his case was that he was taking the child to India without there being any expectation that the mother would play any part at all in the future.
Well, not quite, because that was the paragraph that I took the court to in his statement, where there seems to be an expectation that there will be contact, but then there's a row. There's a row between them on the phone. Yes, it's the preceding paragraph 40. It's back at B160 of his statement. And she said, the applicant sounded very angry and cut me off. This is the 29th of July. She said, don't ever call me again. And says the applicant never called me back or contacted my parents.
Right, so his case was that there was an expectation that there would be future contact.
Yes.
I see. But he did nothing whatever about it, being the custodial parent.
Indeed. And the trial judge had something to say about that, yes.
And what did she say about that?
Where she makes the point that there was no effort made. That the paternal family did nothing to promote or encourage or take any steps to further the relationship, I paraphrase. And then she makes the comment that the maternal family did nothing in return either to pursue any contact.
Seems as if this family has operated in a welfare wilderness.
And that's where the SP, the husband of the mother's sister,
yes,
comes into the scene.
Yes. And do we know whether he visited or not?
Well, the judge didn't make a finding on that.
Shouldn't she have done?
Lord, no. Because
this was August 2017, wasn't it?
Yes. Because in this sprawling case that was going off in so many different directions, for example, the judge heard a lot of evidence about how the mother moved from Mexico into the States back in 2015. What was the basis of her asylum application? What was she doing making a U visa claim? I can come to that in a moment. So thereby, what might be her motivation in pursuing a criminal case against the father, and so forth. And there were so many different directions in which the case could have taken off. Your Lordship, for a moment, looked about the involvement of the FBI and how the father was lured to London and so forth. It's right that she declined to make a finding about the...
I mean, your case is basically that although they were the matters that were closest in point of time, the judge was not obliged to reach any conclusion about such text messages as there were, or about the visit of the mother, apparently, to a lawyer.
Well, my Lord, sorry, your Lordship raises a number of different points. The text messages, she made the observations that we saw, noting what they were not evidence of, where the mother had put them forward as evidence of a proposition they supported her case.
Well, all she says is that they aren't the full... They're obviously not anything like a full record, even if, whenever the parents stop communicating, but because they would have been communication before the departure and so forth as well. But those sequence of messages were all she had.
They were all she chose to put forward. Yes, the mother put forward. The judge had.
And your client didn't put forward anything.
He couldn't.
Yes.
But the judge did look at them. She did consider them. She wasn't invited to make findings, as it were, on specific points, but yet she notes them, observes them, weighs them, and they are there in her judgment. Your Lordship then deals with the issue of the paternal uncle, SP, so if I can deal with that point perhaps. Again, there are numerous references to his evidence. I think it's A64, paragraph 60 of her judgment. That's where she says she's attaching limited weight to the evidence of the witnesses who she believes are clearly in one camp or the other. At A68, paragraph 72, she, as it were, takes SP's evidence, which is the mother's case, as read, assuming that there had been a visit in August 2017 by SP, albeit she doesn't make a finding one way or the other, but she has the clock running, as it were, from August 2017 of the entire maternal family stepping away from A.
Right, so it appears from a rereading of 72 that the judge did accept that Mr. Patel went to the house.
She doesn't make a crisp finding. The father's evidence, and indeed supported by his parents, was that he hadn't. So this was a point where the two camps disagreed.
But how then can she reach the conclusion earlier in the paragraph that it's extraordinary that effectively the maternal family had taken no interest?
Because she concludes that even had SP been truthful, I paraphrase, and turned up on that day in August, and been told to go away with a flea in his ear, that the entire maternal family left it at that for the next 3 years.
Yes.
And then she goes on to make the point that SP didn't even pretend that he was asking to see the boy or for news of the boy or any information. His evidence was that he turned up and they told him to go away or they had called the police on him. And off he went, and that was the end of it for the next whatever years.
So I've read his statement but can't remember. What did he say he'd gone for?
From memory, without going back, I think it was because he was asked to go.
Yes. And for what other reason, apart from being...
To mediate, I'm being told.
To mediate?
Right. Yes.
I see. About what?
The child.
Yes. All right.
So, my Lord, it's right that there isn't that crisp finding. But my submission, as I started, in looking at where there are pivotal findings made on credibility and on key issues that go to the heart of this case, this is one of those peripheral issues that, when highlighted in submission, starts to draw weight because it is an interesting aspect of the case at a key time, but so were a myriad of other points and hairs that were
But
set
so far
right.
as the visit on the 3rd of August to the lawyer is concerned, your response is it's there in the judgment.
Well, it's there. In fact, it's considered at 3 points in the judgment. For your Lordship's note, perhaps it's at A57, paragraph 32, A65, paragraph 64, A73, paragraph 86. So the trial judge very much had it in mind. And as your Lordships have explored, it's then a matter for her when the mother is asked questions around it, and clearly it's dealt with during the 5 days, what weight to attach to it. And one has, as it were, a little more insight on this issue at A72, paragraph 83, which is worth turning to. And perhaps I can, as it were, set that paragraph in this context. The father's case was that the mother was absolutely intent upon securing her status in the United States, acquiring a green card. And she was cross-examined at some length about the effort she went to crossing the Rio Grande in an inflatable rubber tyre, jeopardising her life, going into prison as soon as she was stopped the other side, so forth, and what a driven, resourceful woman she was. And that her priority had become securing her immigration status in the US. In fact, she had previously been married, as I understand it, to a US citizen, but she never secured status in the US. And in this paragraph, the trial judge speaks to what she found to be the mother's lies throughout her evidence, appearing to be a deliberate attempt to support a case on abduction, most probably with a view to improving her prospects of securing a green card and also enabling her to have aid in the USA. So when your Lordships have the court's attention drawn to that one file note with one line that speaks to the mother going, and one has to light upon the words, having a consultation regards to her child being abducted. That's all the trial judge had. Is the mother then on the 3rd of August asking about abduction law, where this might take her? One can see by reading the whole of the file note that she's been engaging with immigration lawyers, certainly since May of that year. And she remains intent upon securing her immigration status. And hence, one has, as it were, an indication of the motivation that this judge saw running through the mother's mind in terms of the steps that she was taking. And then, of course, what the trial judge found to be the extraordinary situation of her, in terms of electing herself or her family to have no contact or seek no news or no word of this boy whatsoever for years.
Would that be a convenient moment? It's a little after 1 o'clock, or if you've just got a very short passage to finish off.
Well, if I've responded to the specific points that were raised, that's
Thank you very much.
Thank you very much. In that case, we'll break off now and resume at... is 2 o'clock all right? Yep. We'll resume at 2 in that case. Thank you.
All right.